by the Office of the United States Trade Representative. In our scenario, the Chilean grape growers and the American distributors have decided to pursue this issue with their respective governments. To support their cause, the Chilean grape growers have decided to call a press conference in Washington, D.C. They hope to demonstrate that the American import requirement is unreasonable and inconsistent with international trade rules. Confronted by the demand of the Chilean growers and their press conference, the United States Trade Representative's office decides to call a press conference of its own to clarify and defend the post-harvest fumigation requirement. Since both press conferences are assumed to take place in Washington, D.C., both will be conducted in English.
Okay, before we start this afternoon's simulation, remember what we're trying to do? It's a press conference. And so what I want you to think about while we're doing the press conference is you're trying to get a message out. So keep in mind, what is your message? And then in getting that message out, what I want you to also concentrate on is tone. The tone has to be professional. You're trying to get a message out to a professional audience, and so keep it as professional as you possibly can. All right? Are we ready? Let's get started.
Good morning, everyone. We are here today representing the Chilean Grape Growers Association, and our main discussion today is going to be about our discontent with the United States requirements on the grapes that we are trying to export to the United States. With that introduction, I would like to give the word to the president of our association, Mrs. Rebecca Velasquez.
Thank you. I'd like to begin by saying that the underlying issue here is that this phytosanitary requirement of methyl bromide imposed on us by the United States is a outright illegal non-tariff trade barrier. It's reducing our shelf life from 7 to 2 days, and it's extending our shipping time and therefore reducing our abilities to profit in the market, as well as it turns out to be a problem for the market in the United States because it doesn't arrive to the consumer on time. And the fumigations that they want us to conduct are against cosmopolitan bugs that are shared by both nations, and we believe that something must be done immediately to lift this non-tariff trade barrier. We'd like to begin with questions.
Yes, over here.
Ben Selko, Los Angeles Times. Can you satisfy us that Chilean grapes are safe for American consumers?
Absolutely. No questions about it. U.S. growers are the ones creating this whole problem. Chilean grapes are being consumed in many places in Chile itself, and they have not created any problem at all. We believe the problem is the actual requirement of this methyl bromide fumigation.
Emilia Sanchez from El Mercurio. Would you agree that this is another instance of U.S. telling the world what they should do?
Imposing this requirement is clearly a method of protecting its own domestic producers. And we and the Chilean government feel very, very confident about this requirement being illegal. And if the United States decides to keep this requirement, we're going to take the case to the WTO, and we are very confident that we're going to win this case.
Yes, Barbara Smith, ABC News. How can you be sure that these bugs are not unique to Chile?
Well, actually, there are some reports, and they clearly state the fact that these are cosmopolitan bugs, aphids and nematodes, and they are found in the U.S. the same exactly they are in Chile.
Then you're saying that you're confident that this cannot pose an environmental disaster to the United States?
Absolutely not.
Welcome, members of the press corps. My name is Kurt Fuller, and I am Deputy Secretary of Agriculture for the Office of United States Trade Representatives. On my left is Dr. Jason Button, professor of entomology at the United States Department of Agriculture. On my right is Mike Nunez, Deputy Secretary of Latin American Affairs with the State Department. I would like to briefly comment on allegations made by Chilean Growers Association regarding U.S. phytosanitary regulations on grape imports from Chile. First, the methyl bromide requirements for grape imports from Chile are designed to protect U.S. growers from pest infestations such as the medfly epidemics of the mid-'80s. Second, this requirement on grape imports from Chile is based on a United States Department of Agriculture study of environmental conditions affecting grapes grown in Chile. This study is available by contacting the United States Department of Agriculture directly. Third, these requirements are in full compliance with the GATT rules governing phytosanitary regulations. Now I'd like to open the floor up for questions.
Chilean trade representatives inform us that U.S. attempts to keep Chilean grapes out of the United States market is an effort to appease the United States grape growers. How do you respond to this?
I'd like to respond by saying that that is categorically untrue. The U.S. is simply applying U.S. Law, which is fully consistent with U.S. obligations under the World Trade Organization. Thank you.
Yes.
Hiroko Saito, Japan Times. I understand Japan has the same problem. Is the USTR working with Ministry of Agriculture, Forest and Fishery in coordinating an approach to this issue?
Yes, we are. In fact, the USDA works closely with the Ministries of Forestry and Fisheries in Japan, and we're looking for ways to find alternatives to methyl bromide use.
The simulation of the two press conferences demonstrates some important principles about getting your side of the story to the press. It must be done in a way the press can use for its own purposes, which is to attract the interest of its readers. An effective press conference must also succeed in shaping the substantive issues in the public debate, taking full account of the concerns and perceptions of public policymakers, legislators, and the public at large. As these simulations also demonstrate, a commercial diplomat needs to be able to acquire a working knowledge of many different subjects. In this case, the nature of agricultural pests in two different countries, the chemical, biological, and environmental effects of fumigants, and the substantive provisions of international agreements. The resolution of international trade disputes can touch on many different areas of specialized expertise. Resolving such disputes may require in-depth knowledge of the scientific facts underlying regulations in areas such as health, safety, environment, industrial engineering, telecommunications, or architecture. It may also require knowledge of the terms of international agreements covering the application of trade measures and domestic regulations to imported goods and services, or to foreign firms. Commercial diplomacy may also be required to resolve purely commercial disputes between firms located in different countries. The dispute might be over whether the supplier met the agreed delivery schedules or quality standards. It might focus on whether damage to goods during shipments were the fault of the exporter or importer, and whether the importer met agreed marketing obligations. Whether the dispute is a private commercial dispute or a dispute with a foreign government, an in-depth knowledge of many issues may be needed. Successful resolution of the dispute may require an in-depth knowledge of the industries involved, including how products are made, how the industry is structured, the relative cost of different inputs, the channels through which the products are distributed, and who the principal customers are. It may also require a knowledge of related social, environmental, and other regulatory issues. A commercial diplomat needs to be able to acquire enough knowledge on a particular subject to be able to identify the right experts, ask them the right questions, and be able to assemble enough basic facts to frame a case on the commercial issue at stake. The commercial diplomat needs to be able to address issues or disputes that touch on a wide range of topics, requiring in-depth knowledge and expertise in diverse areas. The range of subjects involved may include the science underlying health, safety, environmental, and other regulations, the content of national regulations affecting imports or foreign investors, the international commitments made by governments in applying their laws, the organization of the industry, including production and distribution. Since no one can be expected to know all these subjects, the commercial diplomat has to be able to identify experts and research material, ask the right questions in researching the issue, frame the facts obtained from experts in a coherent way to make a case. The final simulation will show how these issues are brought together in the context of a dispute settlement proceeding. Such proceedings can take place in national courts or in international arbitration bodies such as the International Chamber of Commerce for purely commercial disputes between private parties, or the World Trade Organization for disputes involving government regulations. In the next simulation, you will see a hearing before a dispute resolution panel of the World Trade Organization. Having failed to resolve the dispute with the United States government over grape fumigation, the Chilean government filed a complaint against the United States before the World Trade Organization. In such cases, the World Trade Organization can decide to establish a dispute settlement panel made up of trade and scientific experts from third countries. The students participating in the simulation will be representing U.S. and Chilean trade lawyers and dispute panel members from neutral third countries.
All right, class, if you're ready, remember this afternoon we're doing a simulation of a WTO panel, World Trade Organization panel. Just two things I want you to keep in mind while we're doing this. We're applying rules, and we're doing that on the basis of some clearly laid out procedures. Okay, if you're ready, you're introducing the panel. Let's get started.
Welcome to Geneva. This is the first session of the dispute settlement mechanism of the WTO, case 9772, brought by Chile regarding U.S. phytosanitary conditions affecting Chilean grapes. I would like to introduce myself. I'm Kenaz Desai from India, and my esteemed colleagues, Mr. Swanberg from Norway and Ms. Sato from Japan, will be ruling this case along with me. I now open the discussion to the Chilean delegation.
Yes, I would like to thank the dispute settlement panel as well as the United States trade representatives for their participation in this critical trade issue. Chile feels that it has a very strong case before the dispute settlement mechanism today. We are confident that after reviewing all the information, the panel will find our claims to be extremely accurate. Chile claims that the use of methyl bromide represents an illegal non-tariff trade barrier because it reduces the shelf life of Chilean grapes, which therefore reduces the appearance of our product in the U.S. market. Also, the bugs found in Chilean grapes are cosmopolitan bugs, also found in American grapes as well as other grapes around the world. Thank you very much.
I now open the floor to the U.S. delegation.
Thank you and good afternoon. I'm Mike Nunes, legal counsel to the USTR, and this is my colleague and counterpart in Geneva, Jason Bunton. It is the position of the United States government that the U.S. phytosanitary requirement for the fumigation of the Chilean table grape is entirely consistent with the United States obligations under the WTO, and more specifically, the agreement on the application of sanitary and phytosanitary measures. Article 2 of this agreement states very clearly that member countries have the right to take sanitary and phytosanitary measures necessary for the protection of human, animal, or plant life or health, provided that such measures are not inconsistent with the provisions of this agreement. The U.S. will clearly show that the requirement for methyl bromide fumigation is necessary to protect a major portion of U.S. agriculture. Thank you.
If I understand you right, it is in the view of the Chilean government that U.S. regulation is inconsistent with the requirements of Article 3, Section 2 of the SPS agreement?
Yes, that's right, Mr. Svanberg. We have researched this issue thoroughly, and we are confident that the panel will find that U.S. regulations are indeed inconsistent with WTO rules and regulations.
In this case, the dispute involved a government regulation, and so the issue became a matter of negotiation between two governments. Normally, however, before an issue becomes a matter of discussion between governments, the company which faces a restrictive regulation in another country is first expected to make an effort to resolve the issue through direct contacts with the foreign officials involved. Government officials only have limited resources, and they are most inclined to help those businesses that have already made a significant effort to identify the regulatory issues involved and to solve the problem on their own. Where the dispute is of a purely commercial nature, the parties can utilize a number of alternative methods for the resolution of disputes. These methods include direct conciliation discussions between the parties, more formal mediation or arbitration proceedings, or the use of national courts. Other ITC video conferences have explored these approaches and techniques. They are an important part of the toolkit of the modern commercial diplomat. In closing, I want to reflect briefly on the cost of failure and the benefits of success in commercial diplomacy, and to explore whether the requisite skills can really be learned through training and education. The cost of failure in most instances is wasted time, effort, and money. An opportunity may also be lost in reaching agreement on new export or investment possibilities. Obvious failures due to a lack of skill in commercial diplomacy abound. Firms have wasted hundreds of millions, even billions of dollars. Investments have gone sour because companies failed to understand the local environment and to build relationships with the right local leaders. The cost of failure could be a great deal more than lost opportunities. Misunderstandings and failed opportunities to resolve an issue amicably could lead to a great deal of strife and friction between firms and countries. The parties involved could condemn themselves to allocate scarce human and financial resources to a prolonged dispute. They could also lose a great deal of goodwill to resolve other issues. On the other hand, countries or corporations that have developed a well-trained group of commercial diplomats have been very successful in pursuing their international commercial objectives. The trade diplomats of Hong Kong, for example, stand out in their effectiveness and professionalism, as do those of Brazil. Among private corporations, organizations such as IBM stand out for the trained professionals that handle their relationships with governments around the world. Firms and countries that employ better trained commercial diplomats will be more successful in promoting their exports or foreign investments, and therefore more successful in making the firm more profitable or the country more prosperous. Can these skills be acquired through education and training? Innate personality traits certainly play an important role in successful commercial diplomacy. However, the right kind of training can help the aspiring international commercial diplomat to become effective almost immediately upon entering the field. Such training can equip the commercial diplomat with the tools and knowledge otherwise acquired only through a long and costly apprenticeship. Commercial diplomacy and effective international negotiation ultimately are the means for effective global cooperation. The mutual economic gain which comes from such cooperation will contribute to strengthened social and political ties among countries. Thank you.
Thank you, Mr. Fekete-Kuti. Let's begin the first question and answer session. We will try to answer as many questions as possible. Therefore, we ask that only one question be asked per phone call, and that these questions be as brief as possible. You may call the studio directly at the phone numbers or fax which now appear on your screen. We remind you to make your phone calls at a distance from the monitor to avoid feedback. Our first question is from la Universidad Nacional Autónoma de México, Universidad Hispanoamericana, Coalco, el Estado de México, en México.
Good morning. In the simulation that we just saw, the negotiation, what are the real problems that are related to the learning and the teaching of these skills in the university, and what is the participation in these simulations? What is the participation of the teacher in those simulations?
Let me repeat the question. We had a little difficulty hearing it. In the simulation, what are the real problems that are encountered in the simulation for negotiation which we saw on the screen?
I can't think of any real problems. We really had the students just be very natural. I don't know exactly what kind of problems. These simulations followed a number of courses in which we tried to go through the techniques and the skills, and I can't identify any particular problem.
Our next call is coming from Córdoba, El Banco Suquía, S.A., Córdoba, Argentina.
Buenos días. Good morning to all the participants. There is a lot of interference. Hay mucha interferencia. The question. We are seeing here a new profession, a very distinct profession, the commercial diplomat, which is very important now. The multifunctional skills of the professional, do you think that is enough for this professional to be successful?
Dr. Kupro.
Yes, let me tell you, it's not only a matter of professional skills, but also of personal qualities. A good commercial negotiator, be it a representative of a government or of a private business, has to be clear about the goals, the strategy. He has to be trustworthy. He has to have a good command of the facts. And he has to be at the same time firm without being antagonistic, to be able to build a common denominator with the other counterpart. So, in my opinion, it is a very complex number of qualities. Some of them are professional, some of them are personal, in the sense that only the combination of those qualities can make a good commercial negotiator.
Our next call is from KTV Comunicaciones in Rio de Janeiro, in Brazil.
Buenas tardes. What role do the military play here in those countries that are represented in the diplomatic negotiations currently? What is the role that the military play?
Mr. Fekete-Kuti, the question is, what role does the military play in commercial diplomacy, especially in countries that are represented?
Unless the issue concerns a national security issue, the military does not normally play a role. Now, there are, of course, cases when disputes over particular products do come back to security concerns. In fact, Mr. Cooper and I were just discussing one of those cases involving a dispute between the United States and Brazil over informatics a little earlier. You may want to add a few words on that.
Yes, that is true. I would add that in some cases, particularly in countries where the military were in power, they had put in place policies that were justified on grounds of national security, and in a few cases those policies brought about trade conflicts. I would also mention the fact that nowadays there is a growing tendency to look at the human rights record of countries. And we all know by the press that there are a number of countries where problems of human rights and sometimes in military dictatorship have some implications for trade negotiations. But only in this limited way, because I don't think it's very frequent.
Our next question is from la Universidad Central de Venezuela in Caracas, Venezuela.
Good afternoon. Our question is the following. What difference is there between commercial negotiations in the U.S. and those in Latin America and the ones that you have with Europe? And how can you identify in a business an inborn negotiator? How do you identify within a business, within a firm?
Mr. Fekete-Kuti, the question is, what are the differences in negotiations between the United States and Latin America and the United States and Europe? And how, within an organization, would you try to identify a natural-born negotiator?
Well, those are really two questions. The first question is, how would you distinguish between a negotiation between the United States and Europe and the United States and Latin America? Well, there clearly are cultural differences. There's the Latin culture, obviously, which is somewhat different from sort of a mainstream continental European culture. We have people who have backgrounds in certain area studies who specialize in, let's say, Latin American relations, and we have other people who are experts on European issues. So we try to adapt, and I think a firm would try to find people who have a particular background in one area or another, and perhaps they've also studied the culture and the languages of those particular areas. Now, the question of how do you find somebody who has got the inborn negotiating skills? Well, you do that by just trying them out. It's, you find who are your better negotiators. But I should add that not all kinds of negotiations are the same. There are some negotiations. There are like traditional rug merchant.